Welcome back. Our first speaker this morning is Marele Fouché. Marele is an associate in our patent department. She has a master's degree in microbiology and she also has a law degree. She's an admitted patent attorney and an attorney of the High Court of South Africa. Marele works in our patent department. She does patent prosecutions, both in South Africa and abroad, and she has quite interesting and vast experience. Her topic today is going to deal inter alia with, let me just say, the legalization of cannabis, but under very controlled circumstances. So Marele, over to you. Thank you very much.
Good day, ladies and gentlemen, and thank you, Jenny, for that introduction. So let me start off. I'm sure that most of you have heard about the constitutional as most of you probably know by now, in September 2018, the Constitutional Court of South Africa unanimously ruled that the personal and private use of cannabis by adults are being decriminalized. This meant that the ban on private use, consumption, and cultivation of cannabis by adults is now unconstitutional and infringed on Section 14, which gives privacy to all citizens. This judgment, so to speak, lets up the debate between personal and commercial exploitation of cannabis. It should, however, be emphasized that in terms of the judgment, cannabis may not be consumed in public, distributed, sold, or used by minors. The legal limits for personal use since proposed are rather stringent, and exceeding them can lead to prison sentences. In respect of recreational use of cannabis and following the judgment of the Constitutional Court, the Cannabis for Private Purposes Bill was proposed. The bill is currently underway at the National Assembly and it still has to be signed into law. The bill proposes limits on the personal and private and adult use, possession and cultivation, as well as the sharing of cannabis without remuneration. Based on its proposal, the plant and all its constituents will soon be legal. It should also be noted that its regulation under the Medicines and Related Substances Act has already been amended, and I will touch on that now. Okay, so this table features some of the limits for personal use as set out by the bill. Now, I'm not going to go into recreational use of cannabis during this presentation. I'm rather going to focus on the exploitation of commercial cannabis. But just for interest's sake, when the bill comes into effect, it will be allowed for a person to carry 100 grams of dried marijuana on their person in public but out of sight. And for any one of you who are wondering how big or small a bag of 100 grams of marijuana would look like, it would look like something like this. It's quite big, I think, but it's only oregano and mixed Italian herbs. Otherwise, yeah, because the bill is not in effect yet, so oregano. Okay, so as mentioned previously, following the Constitutional Court judgment, regulation of cannabis under the Medicines and Related Substance Act has already formally been amended. These amendments play a big role in the potential for commercially exploiting cannabis. So the whole plant, together with all its constituents, is no longer scheduled as Schedule 7. Schedule 7 drugs are substances that are not useful for medical purposes and have a high potential for abuse. The gazetted amendments to the MRSA Act replace earlier restrictions on the whole plant with regulations that relate to the two main cannabinoids of cannabis, which is non-psychoactive CBD and psychoactive THC. CBD is now amended as a Schedule 4 regulated substance. However, products that contain up to 600 milligram in total recommend a daily dose of 20 milligram and make no specific health claims are exempt from this schedule and are then Schedule 0, which is over-the-counter products. Those are the ones that we mostly see in Clicks and Dischem and whatnot. Okay, so also furthermore, products intended for ingestion where the plant source material naturally contains less than 0.0075% CBD in total is also exempt and classed as Schedule 7. THC is now scheduled as a Schedule 6 regulated substance, except if the raw plant is and its derivatives is cultivated, possessed, and shared or consumed by an adult in private and out of sight. I'm sure all of you have seen the many products containing CBD in almost every shop you walk into. It is now possible to obtain a CBD containing product for almost any part of your body, for any disease or condition imaginable, from mouth spray to lip balm, gummy treats to body butter. It is even possible to obtain CBD containing products for your furry friends. So there are clearly already a lot of competing cannabis-related companies in South Africa. And in South Africa, two of these companies that are making headlines is Psilocybin Holdings and Afrigen Biologics. Psilocybin Holdings recently listed on the JSE. Psilocybin Pharmaceuticals produces numerous CBD-containing products manufactured using nanotechnology. Afrigen are the proprietors of an encapsulation technology for CBD oil, and AgriBiomed Africa has recently secured an exclusive license for the manufacturing of these CBD oil capsules. Furthermore, AgriBiomed has also agreed to contract Afrigen to manufacture encapsulated bulk CBD actives at their facility in Cape Town. So various other companies such as these do exist and are operational in South Africa, and they have invested heavily in the eventual implementation of the legal framework. So the question now arises, how does one lawfully cultivate cannabis and or manufacture CBD containing products in South Africa on a commercial basis? Basically, the cultivation of cannabis for medicinal purposes on a commercial scale requires a license issued by the South African Health Products Regulatory Authority, or SAPRA, as well as a permit from the Director of Health. So the application forms for the license and permits can be accessed online via SAFRA's website or by contacting the Regulatory Compliance Unit. A license can be issued for growing and producing, extracting and testing, importing and exporting, manufacturing and distributing of any cannabis or cannabis-containing medicines. Manufacturers and importers of CBD-containing products, which fall under Schedule 0, as previously mentioned, and is not intended for medicinal use, do not need a permit or a license to import or grow. However, you will have to provide a certificate showing that the contents of the CBD and THC is at an acceptable level. Legalizing cannabis in South Africa could lead to a boost in our local economy, new investment opportunities, job creation, and tax revenue. However, this should not be the only reason for legalizing, as it will prove more difficult for an emerging legal industry where strict regulations must be complied with and permits are needed to compete with an already thriving illegal industry where prices will naturally be lower due to no taxes. With this in mind, it will be important for those in the legal industry to unlock value elsewhere. And arguably, this can be obtained by leveraging intellectual property rights in order to establish South Africa as a dominant player in the market. So once you have obtained a license to grow cannabis, there may be opportunity to innovate by using intellectual property laws. In terms of South Africa, patent laws, plants obtained through microbiological processes, for example, transgenic manipulation of a plant genome, can be protected. Protection may therefore be awarded for either the microbiological process or the product from that process, and in some circumstances, both. So in summary, the following things that can be patented in South Africa is a new microbiological process for producing a plant. Then a new plant produced by a new microbiological process or a known process. A new compound or formulation derived from a new or known plant using a new or known microbiological process. It is also possible to obtain patent protection for the use of a compound for treating a disease if that disease has not yet been treated with that compound in the past. For instance, using Panado to treat cancer. Plants produced using biological means, for example, crossbreeding, are specifically excluded from patent protection. This brings us to the Plant Breeders' Rights Act. Plants generated from traditional biological means can still be protected using a lesser-known branch of intellectual property law, aptly referred to as plant breeders' rights. Plant breeders' rights provide for certain monopoly rights to the breeders of new plant varieties. In terms of the Plant Breeders' Rights Act, protection may be obtained in South Africa in respect of a new, distinct, uniform, and stable variety. In order to be registrable, a plant must be prescribed, and that means the plant must be named in the list of kinds of plants found in Table 1 of the regulations of the Act. And in May 2022, the Act was amended to include cannabis as a type of plant. The holder of a plant breeder's right has the sole right in South Africa to produce, condition for the purpose of propagating, sell or market, import, export, and stock the propagating harvesting material. The duration for a plant breeder's right is 25 years for vines and trees and 20 years for all other cases. And this is calculated from the issue date of the certificate. It is believed that although it is possible to obtain a plant breeder's right for cannabis in South Africa, that application will have to be accompanied by a certificate stating that the THC levels of the leaf and flowering buds do not exceed 0.2%. It is not yet clear who can issue such a certificate. In conclusion, I want you to take away a few points. These points will play an important role in the possibility of commercializing and exploiting cannabis in South Africa. If you want to grow cannabis commercially and for medicinal purposes, you will need a license and a permit issued by SAFRA and the Director General. And as I mentioned earlier, there are a lot of companies already in South Africa, and innovative technology can put you in the right commercial space. And lastly, you can protect your innovative technology using patents, and you can also protect your new cannabis variety with plant breeders' rights. Thank you all for listening, and I invite you to question if you have any questions.
Thank you, Marale. Does anyone have any questions? Yes, wait.
I think that would more speak to the trademark of it.
Yeah, or just generally regulatory aspects. I mean, it relates really to whether or not the product is being, if the product contains cannabis,
Yes.
then it would probably have to comply with, I mean, it depends on what you're claiming. Are you just saying cannabis flavored, or because you do get products that are available like that at the moment, but I don't know if you've noticed the liquor products bill is currently under a massive review, and one of the things that they're going to look at is the labeling of certain products and whether or not any labeling is misleading as to the nature of the product itself. But there are certainly cannabis infused products that are available, but those I don't think relate specifically to patent rights in the plant breeders' rights themselves, but just with regard to flavoring.
And
So-
that'll probably be below the limit to
Yeah.
be scheduled as
Yeah.
Schedule 0, which is
Yeah.
over the counter.
Yeah.
It makes no claim to any
Yeah.
medical assistance or anything.
I think the
But-
difference here is that what Marley is trying to identify is that there are certain rights that you can acquire if you decide that you want to grow and manufacture your own and acquire rights in that specific plant itself. The use of cannabis generally in relation to other products would be regulated by legislation relating to those products. So for liquor products, it's the Liquor Products Act, and for beer, it's the Foodstuffs Act. So you'd have to look at the Foodstuffs Act to see whether or not the placing of an image of that on that product would be misleading or otherwise in relation to the product. But there's currently nothing, as far as I'm aware, which says that you're not allowed to place it on products. Does that answer your question? I think I've gone about a little bit circuitous around you. Okay. Does anyone else have any other questions? I did have a question for you, Marla, and that was, if there's an examination process to get the rights in the particular plant that you want to register, how do they examine the plant? What is the...
Okay, so when you apply for a plant breeder's right and you get all your forms ready and you give it into the registrar, then within a year you need to provide the registrar with propagating material, and that can differ. Sometimes it's seeds, sometimes it's a grown plant, a grown tree. It depends on how fast the plant will grow, so on and so forth. Then you give it to the registrar and they take it to, there's a bunch of facilities over South Africa, for instance, greenhouses, farms, where they do this substantive examination. And what the registrar is looking for is whether this new variety is distinct, stable, and uniform. So with distinct, they're looking at, for instance, let's say roses, and there's never been roses with red petals. Now they see this is new and it is distinct. I can really see this is different than a white rose. And then they tick, it's distinct. And now uniform must mean all the roses that you plant with those seeds must all have the same petal color. And then stable means once you repropagate, it must again show that it is stable and it's red. So it can't fluctuate. That is the whole point of the examination. Okay. Otherwise, it's more of a wild plant and not a new variety that you crossbred.
Okay, all right. And then the rights would be for 20 years, if I understood you correctly. Because
for
not
vines and trees, it's 25. And all other cases, it's for strawberries, for instance, it's 20.
So for cannabis, would it also be 20? Is it a tree? I don't think so. It's a plant.
I must say, it might be a vine. I'm not sure. I haven't that much experience in cultivating my own, but I think maybe it will come up in the private purposes bill, cannabis for private purpose bill, to kind of, because there is still some things that needs to be sorted out. But I think South Africa is on a good track to get there.
Okay, great. Thanks, Marilei. Thank you very much. Thanks, everyone.
Thank you.